Judgment in the matter of Candey Ltd against Crumpler and another as joint liquidators of Peak Hotels and Resorts Limited in liquidation.
Lord Kitchen will hand down this judgment.
This appeal is concerned with the right of a solicitor to secure payment of its costs of acting for a client in relation to legal proceedings, and to do so out of the money that the client recovers or preserves through the solicitor's efforts. This right is called the solicitor's equitable lien, and it allows litigants to secure legal representation which they might otherwise not be able to afford. Solicitors may be prepared to act for persons who have meritorious claims but limited funds, because the solicitors know that they will be paid their reasonable fees out of the proceeds of the litigation. The particular issues in this appeal concern the way in which a solicitor may waive or surrender this lien, and it gives rise to important questions as to how it is to be decided whether such a waiver or surrender has taken place. Candey, a solicitor and the appellant in this court, was instructed by a client which found itself unable to retain legal representatives on an ordinary fee payment basis. In October 2015, Candey agreed to act for the client in return for a single fixed fee, and it also agreed that the client could defer the payment of the fee until it had made a recovery in the legal proceedings or it had entered a formal insolvency process. Candey did not rely only on the solicitor's equitable lien to ensure that its fee would be paid. Alongside the fee agreement, and as part of the same package of agreements, it took additional security in the form of a deed of charge, and it registered this charge against all of the client's assets. The client subsequently became insolvent, and liquidators were appointed. A short time later, the proceedings were settled, so yielding valuable proceeds for the client. Candey's fixed fee had now become payable, and in February 2016, it lodged a proof of debt. In doing so, it referred to the deed of charge as the security it held for the fee, but it made no reference to the solicitor's equitable lien. Some 2 years later, Candey asserted that it had an equitable lien in addition to the security conferred by the deed of charge. The liquidators responded that, in accepting the deed of charge, Candey must be taken to have waived the lien because the terms of the charge were inconsistent with it. The judge and the Court of Appeal agreed. Candey now appeals to this court. It contends that the court should be very wary before concluding that a solicitor has waived its equitable lien by taking additional security, because this would have a chilling effect on the willingness of solicitors to act for clients who are in financial difficulty, and so impede access to justice. It also argues that a waiver by a solicitor of its lien ought to require an unequivocal representation to this effect, and that it has made that representation with full knowledge of the relevant facts. Candey continues that, seen in the correct way, there was nothing inconsistent about taking the new security and retaining the lien, and there was no basis for finding or inferring that the lien had been waived. This court decides unanimously that the appeal must be dismissed. The question whether solicitor has waived or surrendered its equitable lien is to be answered by deciding whether this is what the parties intended. If the parties have addressed the issue, their intention may be apparent from the words they have used. If they have not, an intention to waive or surrender the lien may nevertheless be inferred. This is a matter to be assessed objectively in the light of all of the circumstances. Here it is relevant to consider whether the terms of the new security are inconsistent with the retention of the lien. Another relevant circumstance is whether, in the light of the professional relationship between them, the solicitor has explained to the client that it wishes and intends to retain its lien. If the solicitor agrees new security which is in any way inconsistent with the lien, and does so without explaining to the client that it intends to retain the lien, then it is very likely that the lien will be treated as having been surrendered. That will be so even if the client is encouraged to take, and does in fact take, independent legal advice. Application of these principles in this case yields a clear answer. There was a continuing relationship between Candey and the client, and insofar as there were inconsistencies between the new security and the lien, it was for Candey to make clear that it intended to retain the lien if that was what it wished to do. There were at least two inconsistencies between the new security arrangements and the retention of the equitable lien. First, the deed of charge constituted consensual security over the settlement proceeds and other assets. By contrast, the lien conferred a right to ask the court to impose non-consensual security over the settlement proceeds. Secondly, an equitable lien would normally rank first in priority for payment. The deed of charge, on the other hand, conferred priority on another charge in favour of a third party, and so ranked below that other charge. This court is very doubtful as to the relevance of a third matter relied upon by the Court of Appeal, which was a term in the fixed fee agreement for the payment of interest. Nevertheless, in the light of the two established inconsistencies, it is important to consider whether Candey expressly or impliedly reserved the lien when entering into the new arrangements. Here, Candey relied on various provisions in the fixed fee agreement and the deed of charge, and also upon evidence of a conversation between Mr. Candey and a director of the client. The Court of Appeal was not persuaded that any of these amounted to an express or implied reservation of the lien. This court agrees. The judge and the Court of Appeal were therefore entitled to find that Candey waived its lien when the parties entered into the fixed fee agreement and the deed of charge in October 2015. For all of these reasons, the appeal must be dismissed.
The court will now adjourn.